On this episode of I'm Not a Lawyer, but the Debrief.
When you don't object in the middle of it,
Right.
are you able to later say, hey, I meant to object. I'm sorry I didn't, but I got to object now. So in this instance, it's like they're trying to go back. Can they?
You know, again, it was such a unique situation that we're in because it could have gone the other way.
Now, if you're not ready, then go ahead and just tell me you're not ready.
I object to you getting records. You've been intrusive into people's personal lives.
In other words, the car didn't hit him, and he wasn't hit by the car.
I'm not a lawyer, but
are y'all keeping up?
I'm not a lawyer, but
The Debrief.
Hello and welcome to another episode of I'm Not a Lawyer, but
The Debrief.
I am Melanie, aka Mel, because that's also what I go by.
Mm-hmm.
And another aka is I'm Not a Lawyer, but, and I am joined by my co-host
Gooseby. How y'all doing?
and we are here with another episode of this podcast to talk all the things that we know about and also know nothing about because we are not lawyers, but we act like we know things about legal stuff. So we have been covering YSL as well as Karen Reed and other things that come up. But we're going to go a little bit out of order as far as our regular segment setups. So we're going to start with a segment that we call the sidebar, okay, which is just a little bit of a side topic that we'll talk about, still related obviously to legal stuff in court and trials and all of that. And then we'll go into Mel's mini bar, which will be done in conjunction with the open bar, which is the main topic of our podcast. So we're going to start with the sidebar, and today's sidebar is YSL.
YSL.
Because there's been a lot happening in YSL. And I just want to give a recap about what that is. There were motions filed to recuse Judge Ural Glanville, who is overseeing the YSL RICO case. There are these motions from Brian Steele, who represents Jeffrey Williams, aka Young Thug, as well as Diamante Kendrick's attorney, Doug Weinstein, who was a guest on this podcast. They both filed motions to have Judge Glanville recused. Initially, Glanville said no to all of them immediately. Then he had a bit of a change of heart. And you can speculate as to why he had a change of heart. I would assume it was just the mounting pressure publicly, but also maybe kind of internally. But he eventually changed his mind and he sent the motions to recuse over to another judge. So that judge has been assigned. Her name is Rachel Krause, Judge Rachel Krause. She was assigned to specifically, not to the overall case. She is assigned to oversee if Judge Glanville should actually be recused from overseeing the RICO case. So that is specifically what her role will be. So because there is a motion, right, filed by the defense, the state, okay, Attorney Love, Attorney Hilton, they have to respond to these motions. So defense is like, hey, he doesn't need to be overseeing this. He needs to be recused. And the state gets to say, we don't agree. He shouldn't be recused because of X, Y, and Z. This is why we say he shouldn't be recused. So Judge Krause gave the state until Monday, which was yesterday. We're filming or 2 days ago. We're filming this on Wednesday, to give their written response as to if they say Glanville should be recused or not. At the very last minute, Attorney Love, the lead prosecutor on that side, said she had a family emergency and I need an extension. And so now her written response as to if Glanville should be recused is expected today, which again is Wednesday by 5 p.m. So we are waiting for that to see what she's going to say, what her reasons are. I assume it's going to be very similar to what she said in court, which is that it was a civil matter and that ex parte meeting was not a big deal and it has nothing to do with the defense. So that is what we're waiting on for that. In the meantime, Doug Weinstein, and Brian Steele filed motions for Judge Krause, this new attorney, to also be recused from the case.
Hold on. Judge Krause?
The new judge, they filed motions to have her also recused from overseeing the recusal of Judge Glanville.
Okay.
Yes.
Why?
And so a couple reasons.
Okay.
One of the first reasons that Doug Weinstein included in his motion, he said not only should Judge Krause be recused, but all of the judges that sit in Fulton County Superior Court should be recused. And essentially his reason is because Chief Judge Glanville, he is the chief judge. He is the chief judge for Fulton County Superior Courts. These are essentially his colleagues. He works with them. They have some kind of relationship. They sit on the same circuit, right? Okay. And so he cited some case law that says that basically when you sit on the same circuit, you can't oversee the recusal of one of those judges because it would be a conflict. That's essentially what he said. Now, Brian Steele yesterday filed a hilariously fire motion to also say Judge Krause should be recused, as well as Judge Glanville, as well as the DAs, the prosecutors. But he says Krause should be recused because he said that back in April of this year,
tell me about it.
Glanville donated $2,000 to Judge Krause's campaign. And so he said that is a conflict. And so you need to be recused because that's your friend and you gave him some money.
Yeah.
So that is what he said. He also, like I just said, he also said in that motion that Judge Glanville again should be recused. And he said that Attorney Love and Attorney Hilton, okay, the DA's office prosecutors, they should also be recused. He said everybody should be recused from this case because y'all are doing a bad job. Y'all are trampling, I think was his words, trampling over my client's constitutional rights.
So everybody in Fulton County.
Everybody, essentially, he's saying that this case should be taken out of Fulton County and, he's saying the recusal should be handled by a judge outside of Fulton County, 100%.
Oh, okay. That's what I heard about. They're going to move it to Savannah, Chatham County.
They're not going to, but I think maybe I forgot what we were watching.
That was a suggestion.
Yeah, okay. Because one of the things that happens, which was news to me, but very interesting, is that when a case is moved out of the county that it should be in, it's supposed to be moved to a county that has similar demographics. So when you think about the demo of Atlanta, Fulton County, right? You think about what those numbers looks like, the ethnicities, the ages, all of that stuff, even the socioeconomic status. When you think about that, you have to find a county that is comparable. And so I think what that's one of the most comparable demos to Fulton County
in Georgia. Yeah.
So that is what they were arguing. I did a full recap. I read Brian Steele's motion, which was sassy, honey. It was funny. So if you want that full reading, go check it out. I did a live on my YouTube. It is a good time. I also did just a mini recap of it, but regardless, it was funny. He said that they should all be recused. And then this is why I needed a couple minutes to go through this. Judge Krause responded already to them saying she should be recused. She was like, hold up.
She in Fulton County, man. You can't.
She responded.
That. Okay.
And she said no. She said, I'm gonna let you finish, but no, I'm not gonna be recused. And the reason that she says she doesn't have to be recused, two reasons. She answered Brian Steele, but she also answered Doug Weinstein. And so in response to Brian Steele saying that she should be recused and based off of the donation, right, to from Glanville, she cited the Supreme Court as well as a judicial committee. I can't really think of the full name, but basically when there is a multi-judge circuit like Fulton County, so there's many judges in this one circuit, this judicial committee or rule, it's a rule, says that judges can oversee recusal motions for other judges, even if they're in the same circuit, as long as whoever the recusal motion is assigned to is randomly selected. So there's supposed to be a system that just will, hey, you're going to be the judge. And so according to this rule, as long as that happens, she essentially doesn't have to recuse herself. There is no conflict. In addition to that, when it comes to the donation.
That's what I was about to say.
She says that the Georgia Supreme Court has
Mhm.
ruled that as long as the donation is not a ridiculously high amount, and I can't remember the exceptionally large, I think is the actual terms in the Supreme Court ruling.
Mhm.
As long as it's not exceptionally large, you have to have more than just that reason.
Mm.
So,
And this one was only $2,000.
and it was $2,000. And then there is another rule that she cited, which said, because the other question, right, is like, okay, so how do you define exceptionally large? Because $2,000 is exceptionally large to me because I ain't got a lot of money. But maybe to somebody else, it's like, that's chump change.
True.
And so there is a maximum allowed by law, is
Okay.
what it says. And if your donation doesn't exceed the maximum amount, then you have to have another reason in your affidavit. You have to say, hey, they donated, but also here are the other reasons why this judge should be recused. And because that wasn't included, she says denied.
Hey,
Mm-hmm.
she did that
right?
one.
I read it like, okay.
I was about to say, because the
I'm not a lawyer.
conflict of
You
interest.
might be one.
Yeah. Conflict of interest, giving the money, donating it. I was like, oh, well, you can't fight that.
Yep.
But apparently you can.
Apparently you can. And then in regards to Doug Weinstein's motion, she also said, so when you file a recusal motion, it has to be done in a timely manner, which is in 5 days from whenever the incident happens that is sparking you to say this judge should be recused. So you have to do it within 5 days. And you also have to file it properly. And a recusal motion is supposed to be accompanied by an affidavit. So the motion filed by Doug Weinstein didn't have an affidavit. So she said, you didn't file this right. You didn't file it properly. So I'm denying it because it wasn't filed properly. But then she said, even if you go back and add the affidavit, it's still no.
Yeah, it passed 5 days, Playboy.
Well, no, it's still no because of the reasons that she said to Brian Steele. So even if she amended it, even if Doug Weinstein amended it, she said in her response that it would still be a no. So that was a lot. I hope y'all followed it. That is the latest. Okay, good. So she is not, as of now, she is not going to be recused. She is going to be overseeing this recusal motion for Judge Glanville. We are expecting today the state to respond. And so the next thing she has mentioned, Judge Krause has mentioned that a jury is currently waiting, right? This trial, we are in the middle of 9 months into this trial. And so she's like, we have to do this quickly. And so that's why she said, you need a response by Monday. Okay, I'm gonna give you these 48 hours, but we have to move quickly. So I am very curious when the state responds, what's next? I'm curious. Are we gonna have a hearing very soon? Are we gonna have a whole recusal hearing to hear? Is he gonna put Glanville and Love and Hilton on the stand and ask them about that ex parte meeting? It's going to be very interesting.
That will be wild. But my question is, you said the jury is waiting.
Yeah.
They're keeping the same jury?
Yeah. This is not over right now. We are in she could say, hey, Judge Glanville doesn't need to be recused. Pick this back up. And we could go back to trial and go back to regular days again.
Judge Krause could do that.
Yeah.
She could say that.
If she said there's no reason for Glanville to be recused, we will go back to the way it was 2 weeks ago. But the thing is, right, what I'm saying is the jury who have been going to court most days, not every day because the schedule has been crazy, but they've been going to court for the last 9 months, hearing these testimonies, and so now they're just on break for 2 weeks. Would you be on the internet searching what's going on? Or no?
Hell yeah. I would be all up in there. They probably been doing it anyway, but I mean, you can't escape it.
That's what I'm saying.
It's
Imagine
on every platform.
Everywhere. I hope they didn't ran across a couple I'm Not a Lawyer But videos. I promise you I do.
They probably having
Hey,
cookouts.
What's up?
Family gatherings.
Yeah.
Man, let me tell y'all about this here.
Well, and think about this. The star witness that really started all of this, Kenneth Copeland, aka Woody, has been on the internet. He's been doing interviews. He's been doing lives.
Yep.
He started his TikTok page. So as a juror, imagine you're scrolling on TikTok and run across Woody, run across an interview. Imagine. Yeah. And on top of that, Woody was in the middle of testifying.
And then other lawyers have been on podcasts.
Yes. So it's like, imagine, even as Woody, right? Because even if you're naive to this process, you're testifying, you don't know. He was in that ex parte. He didn't know it was wrong.
Oh,
But now you'd imagine he does.
the jury, did they know about the ex parte?
No,
meeting?
no,
So,
no.
but they know now.
Exactly. All of this stuff has been exposed at
Oh,
this point.
man.
Like, you've tainted this entire process.
They need to throw everything
I don't
away.
know how they pick this back up. I don't know how you continue this. I just don't see a world in which it's like, just kidding. Let's keep going.
See, that's the thing about the internet. It's on the internet.
It's on the internet.
You can't escape it.
Woody is going to get back on that stand and they are going to ask him a question. And I can't even imagine what that man would say. I can't even imagine.
He probably say, go to this podcast
Literally.
episode.
Woody versus Woody on it. Like,
you get the answer.
Yeah. So anyway, he is
Woody.
low-key going viral. Somebody is commenting in the Patreon. He has low-key gone viral. So imagine, there's no way a jury is escaping all of the press that's been going on with this case. I just don't see. I don't see a world in which it continues, but I'm not a lawyer, so I could be wrong. And we're going to keep watching to see what happens.
That ain't got nothing to do with being a lawyer. The internet, you going to know what's happening.
Yeah.
Yeah. Especially in Georgia, Atlanta.
So that is the sidebar. We are going to continue on shifting gears.
That was a big sidebar.
And go on to Karen Reed.
Mm-hmm. We're going to Karen Reed. At the entire time the Karen Reed case was happening, you had one person there for sure every day, front row and center. His face never changed. He never reacted to anything. And his name is Paul Okeefe. So that's John's youngest brother. And I was always wondering what was going on in his head because
I think all of us were.
Yeah.
The question was like, how does the family feel about all of this? What is John O'Keefe's family thinking? 100%.
He did an interview explaining how he felt, how his family feels. And it was interesting.
Do you feel comfortable telling me, just from all that you've learned over the last 2.5 years, like what you think happened that night?
Oh, we know what happened. We know that Johnny and Karen were arguing. It was kind of towards the end of their relationship. Things weren't well. They were drinking and arguing and fighting, and in an intoxicated state of rage and jealousy, she just decided that she was going to do something about it, and put the car in reverse and ran him down and left him there to die. She told my wife that just have to remember the bad times, and I don't think I'm ever going to talk to you guys again. Mm-hmm. Why would somebody say that? Why would someone say, if you didn't do anything, why would you say you're never going to talk to us again? Or why do you have to remember the bad times? Almost like justifying what you did.
So if these people buy into this big conspiracy, right, that Brian Albert's a murderer or whoever, okay, if they buy into that, why are they turning on you guys? Has that ever made sense to you?
Because we don't believe in a crazy conspiracy theory that holds no merit, no evidence. I mean, we know these people. I mean, Jen McCabe has been a family friend of ours. She was friends with my sister. Kerry Roberts we've known for a very, very long time. I guess the negative or hate that's directed towards me, mostly me and my mother, is because we support these people who are being falsely accused of something they didn't do, right? And their lives have been turned upside down and partially ruined.
I mean, there were certainly some moments in the case where there were weak spots exposed, right? Like, I think about the solo cups and Trooper Proctor, who now is facing job consequences as a result of this.
Well, as far as at the very early stages, I mean, a crime scene during a blizzard can't be an easy thing to navigate. And yet, they found evidence, they found a sneaker, they found pieces of taillight. Obviously you're not going to see everything under a couple feet of snow. Mm-hmm. So I think they improvised the best they could. Every investigation is going to be kind of scrutinized to some degree. But they did what they had to do with what they had, and with the weather conditions being what they were, they just, like I said, had to improvise and do the best they could. As far as Michael Proctor's comments, I mean, he even said too they were unprofessional, which we agree with. But this guy, his life's been ruined. Getting his personal cell phone, which was something that should never have happened.
How are your parents?
They're doing all right. That's more of my concern, is that they have to go through this again. I mean, I'll do it 10 more times if I have to, but I hate the fact that they have to go through this all again.
Has your circle of the people who support you guys, has it grown? Has it gotten smaller over the course of all the noise outside of this?
So for me personally, I've kept my circle smaller. Mm-hmm. People that you were friends with or haven't seen in a while, you just don't know where their mind's at.
Yeah.
What they believe. So we've been forced to become very kind of defensive, not as outgoing as we normally would be.
Mm-hmm. We got ushered out of the courtroom pretty quickly on Monday. You had a little exchange with Karen. Do you mind? What happened there?
So throughout the trial, she likes to turn and look at me and smirk. She's never once made eye contact with my wife, Erin. So when the mistrial was announced, she turned and looked right at Erin and gave her a smirk, and then went over and hugging and celebrating to some extent. And I just said, you're not done yet.
And there you have it. That answered my question. Paul is with the
he is more than with
Commonwealth. Well, first, I would like to say I'm sorry that John lost his life, and him talking about his parents and how they're doing shows these people they are human. Okay, so I just want to say sympathy and sorry about that. It's hard to, well, I wonder if he's taking in the evidence like we have taken in the evidence, where it shows so many, the defense poked so many holes in the Commonwealth's story. It's like he's just overlooking it. And it's just confusing to me. It's like he's like Proctor, how Proctor was like, she did it, no matter what, she did it, and he's not even having an open mind about the situation.
Well, you asked me a good question, which was, if it was your loved one and your family member and the police, right? And your brother is a police officer and the police come to you and say, this is what happened.
Mm-hmm.
Would it be hard for you to believe a quote unquote conspiracy? How easy would it be, or hard would it be, to go with this other version of events versus the police? Is it hard? Is that a hard thing to overcome? So in that regard, I can almost understand, but I'm probably not a good example too, because I'd be defund the police sometimes. So it's more likely for me to not believe the police, but also I don't come from a family of anyone who worked in law enforcement. I don't know a single person in my family who did. So I am probably, I can be a little more skeptical, but because that's his brother, I just wonder if that's why him and the family are just believing that. But I'm too much of a realist too. If I'm in the courtroom and you telling me you use solo cups, and then you telling me people just walked outside and missed a body, boy, bye. That's so hard for me to get over that hurdle.
That's true. That's exactly true. I would fight tooth and nail for my brothers.
Yeah.
They're right. Whether they're wrong, I'm gonna say they right, and I'm gonna stay by them.
Yeah.
This is to the core of me. I would go to jail for these boys. All right. But then when you bring the evidence to me, and how we know their evidence is about as strong as when you catch your child lying and you're like, okay, tell me the truth.
Yeah.
And you know whether or not, well, you know they're lying.
You know they're lying.
And you're like, I'm going to give you one more time.
Yeah.
Because I've been through this myself. You're lying.
Yeah.
This is how their evidence is coming across. And after that, it'll sway me the other way. And I would just be sorry. Like, bro, you did this, man.
Yeah.
The evidence is here. There's no way around, like, fact after fact after fact. I can lie for you to a certain point. So I can lie for you to a certain extent. But after all this evidence, I'm in the corner now. I can't do nothing.
Yeah. 100%.
Yeah.
So anyway,
then he tried to sympathize with Proctor, talking about Proctor's life has been ruined. After, that's no, brother. Nah, Proctor's wrong. He got caught. Suck it up, take your blows, and move on. He's probably gonna he did get suspended or fired, right?
He is
leave without pay,
transferred or something like that.
Yeah, he gonna get transferred and still be a police officer.
There's a ton we could go in about that interview, but we have a guest.
Yes,
that we are so excited to bring to the stage and engage in a conversation, because more things than just this interview has happened in Karen Read over the last few days. And so I am going to bring her up. Okay, so we are so excited to have attorney Morjieta.
Yes.
Did I say it right correctly? Okay.
Awesome.
Here with us, she is a born and raised Boston attorney. And we are going to talk all things Karen Read. I got some questions I would love to have your lawyer insight on. So
Absolutely.
we are excited to get into it. But before we do, I want to go into a segment of the podcast that we call Mel's Mini Bar, because I'm not a lawyer, but sometimes I act like I want to be one, and I do research on legal terms, and then I bring it to the audience and explain what things mean. And so anytime we have a guest lawyer with the real knowledge, I love for them to be the guest to do the Mini Bar. So with that said, I would love if you could explain what mens rea is. And I know that there are a couple versions of that, what that means. And so we can talk, if you could explain what that is, and then we can kind of relate it to Karen Read and the charges that she was specifically facing.
Absolutely. That in and of itself could be its own show, right? But we're going to try to narrow this down as best as we possibly can. So when you're charged with a criminal offense, right, you really have to look at what the elements that you're being charged, what are being charged against you, right? Now, this theory of mens rea really just talks about what your intent was at the time that the incident occurred, maybe sometimes before. These are some of the things that can point to whether or not the prosecutor or the Commonwealth or whatever jurisdiction is charging you with that offense, if they can point to the fact that you actually meant to do what they're charging you with. Now, some charges don't actually require this mens rea element, right? So if things are done on accident, but you could have prevented the accident, they may not have to show this mens rea, also known as intent, to move forward with the charges, right? But there are specific types of cases that you have to show, I know what that defendant was thinking at that time, or articulate certain activities that the person had to show, I know what the defendant was thinking. They meant to actually do that. And that's actually something that the prosecutor has to show in their case in chief.
Got it. And mens rea, the Latin translation of that is literally guilty mind, right?
Absolutely, right.
Okay.
And so you're piercing into what that person was thinking at the time, because we don't know what's going on in people's minds, you know, when things happen. But yes, that's what it translates to.
Okay, so I want to again, I do a little bit of research, so you can feel free to chime in and correct and do all the things. So like you're saying, guilty mind, mens rea. So when you act intentionally, right? It's a person acts with determination or intentional to commit this act. And that is, as an example, if someone were to assault, let's say I assault my husband, which I don't do, amen. But if I were to assault him and intending to actually harm him, that would be
Absolutely.
guilty mind.
Right.
And then if there's a version, you kind of were talking about when you do something knowingly, so you commit an act with awareness that it could result in danger. Is that accurate?
Absolutely, yeah. And so the textbook definition for the second one that you talked about is driving a car in a playground, right? So you know that there are going to be, you can presume that there'll be children in a playground, whether you see the children there or not. The reasonable presumption is that you would know that a child could be in a playground. So if you recklessly or dangerously drive your car into a playground and a child gets injured, that could fit into that particular knowing element if they were going to charge you with some sort of like vehicular homicide or something like that, even though you didn't know that particular child would be there. That makes sense.
Yep, it does. And then there is acting negligently.
Absolutely, yeah.
Okay, and go ahead.
So when you act negligently, right, that just means that, again, you have to have a certain level of awareness of what's happening in your surroundings, and you disregard that anyways, and you still continue on with whatever that particular behavior is, right? So we all have, if you have a driver's license, you have a driver's license as a privilege, not a right? And as a privilege of having this driver's license, there are rules. If you don't obey those rules, let's say you know that moving the steering wheel is going to swerve the car, right? So that would be a negligent behavior. If something happens as a result of that negligent behavior, then you could be found responsible for anything that happens subsequent to that.
Got it. Perfect. Okay, so with that, go ahead.
So mens rea is a charge, or it's just an umbrella of?
It's a theory. It's a legal theory that is interwoven, so to speak, into the elements that somebody is charged with, right? So the layman's term, as they call it, is intent, right? What it was, the intent. Can you show that this person intentionally did something or knowingly did something and still chose to disregard it anyways and move forward with the act?
Okay.
And so a good example that we can connect it to is Karen Reed and the charges that she was facing. So there were 3, and the first was second-degree murder. And there is intention required with that. Is that accurate? Can you?
That is accurate, yes.
Okay.
And so, across the board, this case has gotten so much attention and people are talking about it left and right, up and down, right?
Yep.
I think the consensus, even from myself talking to prosecutor friends of mine, they all kind of felt that was overcharged. And when we say overcharged, meaning that the Commonwealth could have brought in any other forms of degrees of murder or homicide, but they specifically chose second degree murder, which has this what they call specific element to intent that is really hard to prove, just as a general basis, right? It's really hard to prove intent because you have to have certain circumstances and certain facts to show that this person knew what they were doing and still continued on with whatever that particular act is. So in the Karen Reed case in particular, the prosecutor was trying to, and we'll talk about this, I'm guessing, with the next part about what you're going to ask, I'm sure. The prosecutor's job was to show that Karen Reed actually intended to kill John Okeefe. Like, that's the plain language of what it is, right?
Yep.
That's the burden that they had to prove. Now, did they meet that burden? Everybody, you can have your own differences of opinion. Now there's other things coming out.
Yes.
These jurors, but that's the benchmark that they had to prove. And I think it was really hard from the beginning. People were just saying that we don't see how you're going to prove the intent part, right? And so that's always that challenge in that particular case and that particular charge. How did you know? How are you going to prove that you knew that she knew that she actually intended to kill?
Yeah. In general, is mens rea difficult to prove? Like I hear it, even we've been following YSL, and sometimes I just hear them throw out mens rea. And what I gather from that, like even in the context in which they throw it out, is that it can be really difficult to prove someone's state of mind when they did an action. And so it has to be supported by many times other actions that would indicate what their intention actually was. But in general, it seems really difficult to do.
It is really difficult to prove, and you have to have really good articulable facts in your case to show that any reasonable person, right? And we're talking about beyond reasonable doubt, right? And not beyond all doubt, but beyond reasonable doubt. That means that there is a likelihood that this particular fact will show that anybody would have to believe beyond a reasonable doubt that this person meant to do that, right? So simple one. If you are in a club, somebody pulls out a gun in the club, starts shooting inside of a nightclub, and someone is injured or dies, right? Those set of facts are pretty, and if you can point it obviously to that person, those are going to be pretty straightforward to show that, hey, a person shot up an open club, right? They intended for somebody to be injured, for somebody to be hurt.
Sure.
But sometimes it's not always that straightforward,
right?
There's other facts that are happening at the same time. People are there, so it's not super clear.
Yeah. And I think even in this case, we heard these voicemails of Karen Reed angry, and that appeared to be the way the prosecutors were trying to show that she had some intention. She was angry, she was mad, she wanted out, and so she did this action in order to get out of the situation. But one of the things, I mean, in listening, it's like, yeah, she was mad. That don't mean she killed him.
Exactly. And that's the point there. And I think the other thing is too, especially with the long drawn out witnesses and things like that, it was really hard to focus on that when you had other issues simultaneously going on that really weren't explained, by the prosecution's case in chief, right? And as you stated, being angry with somebody, especially, they didn't really make that causal connection with that day. So if I'm mad at you Sunday, and something happens to you next Sunday, does that mean that it's as a result of that first Sunday? And I think that they were trying to make that connection, and it was a missed connection, right? But even if it was, like, you would still, even if it happened the same day, right? Sometimes they have this what they call heat of the passion, element of certain crimes, right? The textbook definition for that is you come home, sorry, my friend, your husband cheating on you, right?
Oh, it's gonna be heat of the passion.
You're still in the bed, right? And you lose it, right? And you lose it, and unfortunately, you injure them, whatever. That is called, heat of the moment. But they would still have to, show that. And even in that could be a defense in certain cases, right? You were so blindsided by what was happening. But they would have to make it closer in time. And in the Karen Reed case, it was too far off.
Yeah, because at both locations, at the bars, they had no issues. They were hugging, kissing, drinking. And that's the other thing. She was drunk. They proved that she had 9 drinks. So if you're intoxicated, you're probably not aware of what's happening or remembering what happened, or
Absolutely.
So how you going to
prove? And I think that was actually interesting that you say that, because again, the defense didn't have to put on any theories at all. I think at the beginning they estimated that their case was going to take about 2 weeks after the 9 weeks that the prosecution put on, right? But I think as time went on, they didn't even raise that really as a defense, the fact that she was drunk, because like I said earlier, there were so many other pieces that they really did an excellent job in painting towards the not guilty elements, that they didn't even have to bring that. I don't even think it was even mentioned in like the closings or anything like that. They kind of just like put that to the side. But yes, to your point, that could have been a defense, could have been, in the overall case, but there were so many other things that they didn't even need to go there. You know what I mean?
Totally.
And it is what it is.
When you bring up alcohol, that actually points to the next charge that she had, which was vehicular manslaughter.
Right.
And that charge, can you talk a little bit about it? It has to do with being intoxicated and operating a vehicle.
Yes. And I think this is, again, with the new information that's coming out,
Yeah.
supposedly this is where people were struggling, right?
Right.
Because you can't deny the fact that she was drunk. Okay.
Mhm.
That's a fact that was really not disputed.
Yep.
The issue with the involuntary is, was it reckless, right?
Right.
Was that, even with the intoxication that she had, was it reckless behavior? And they still had to have a knowing element, right? Of course, that could be diminished with the alcohol intake that was in there, but I think that there was, again, just backing up, they have to prove each of the elements
Right.
in the involuntary, not just the fact that they knew that she was drunk, or the fact that, allegedly she had something to do with, his death, but they have to connect all those pieces together in order for that count itself
Yeah.
to be a guilty or a conviction. And I think that's where people really struggle, because
Mhm.
a lot of the pieces in between, the elements, and, jury instructions are hard. I think this is something that, we'll get into a little bit later too, but the way it was explained to them too may have been a little bit confusing, which is why they were split on that particular issue. But yeah, the main focus for that piece is the recklessness, right?
Mhm.
How are you what facts that were not in dispute could they have pointed to that it was reckless? I think they were trying to say, because she went to her parents' house, at like 1:00 in the morning, the 50 missed calls or 50 calls that she tried to place to him, during that event, could have pointed to that. But I think it still wasn't their strongest piece. Again, I'm sure we'll talk about it later. If they retry it, I'm sure they're going to go back in and try to tweak and, figure out what evidence they could use. But it was still a missed piece on that point.
Got it. Okay. And then the last count that she had was leaving the scene of the incident with someone who is injured or dead. And there is intent, or there is a knowing piece to that charge, right? You have to, if you hit someone and leave, but you didn't know you hit someone, that is different than if you hit someone, know that you hit somebody, and then you leave. That is a hit and run.
Mhm.
Yeah, absolutely.
And so that was the third one, right?
Right. And so, and that is why I think, the 1 and 3 charge supposedly we're hearing now were pretty unanimous, because you either believe she hit him or you don't believe that she hit him. If you don't believe that happened, then 1 and 3 are kind of in the same boat, because you have to believe certain facts to reach the decision on those two. But then it boils down to a second piece. If she did know, did she leave intentionally and leave him there? And I think, the whole Google search with how to die in the snow came into play. But again, that was, neither expert really kind of proved or disproved if it was 2:00 or was it 6:00, because that could have made a difference. But I think that knowing element is still there, which is why allegedly there was pretty much a unanimous decision on 1 and 3, because you had to have believed those facts that she hit him and did so knowingly and just left.
Yeah,
and I think that was the hard part.
Sure. Exactly. Okay, great. So we went through the counts, and hopefully you guys are all clear on the knowing part, the intentional, the mens rea part. And now I want to talk a little bit about what you've been hinting at and alluding to, which is in the last couple of days, Alan Jackson and David Yannetti submitted, there was a motion, and with those motions were some affidavits.
Yes.
And in the affidavits, they say that they have been contacted either directly or indirectly by jurors from this trial who say that they voted that she was not guilty on count 1, second-degree murder, not guilty on count 3, knowingly leaving the scene when someone is injured, but they were deadlocked on count 2, which is that vehicular manslaughter charge.
Right.
And so I can't wait to hear all your thoughts on this, because
there are so many thoughts on this. But let's just start with the actual motion itself, right?
Okay.
So I'm going to take one step back. Let's talk about the jury process itself.
Okay.
So the jurors in this case, and all jurors, take their job very, very seriously. They really adhere to the not doing any independent research. They really adhere to not talking about the case outside of, the court hours, not communicating with family. And I can really tell that this jury really did have enough time to deliberate. That was one of the questions that happened, during the trial. Where the prosecution said they didn't have enough time, defense said they did have enough time. So in my opinion, I think because the trial was so long and so drawn out, some of them, from what I've heard from other experts who were there in the courtroom, they were tired. They went through a lot of the information was chronologically didn't make sense. So I think for the most part, them going into the deliberation room, we may never know, but I feel like they already had a consensus as to what they were going to do with the 3 counts before all of this kind of happened. So I just want to put that, to the side, that this was taken very, very seriously.
Yep.
Jurors in general, in my experience, don't reach out to the defense attorney. So this is a really unique situation in which they would reach out directly about what happened in the deliberation room, because that is supposed to be a sacred space for them. It shouldn't be a space where I speak my piece and then later on it'll be used against me because that's how I felt about the case, right?
Is that ever said directly, out of curiosity? And I hate to interrupt you, but is that this is a space that should remain confidential in between these 4 walls? Like, is that ever said directly to a jury, or is that just kind of understood?
It's an understood principle.
Okay.
I think that, sometimes judges will go back and talk to the juries and let them know that they should feel comfortable in this space. A lot of commentators too, you'll hear them talk about it's a sacred space, because it is, right?
Yeah.
And it is an understood principle that when they go back into the deliberation, what they talk about is amongst them. And that brings me to, this other point, which I'll get to in a second about coercion and feeling pressured and things like that. But you will have at the end of a trial, and I've had at the end of the trial, the jury talk about your performance and, things that you could do better and points that you made that they really like. Sometimes it happens, doesn't happen all the time. It really depends on the judge. It sometimes will come from the judge, or sometimes after, they'll come up to you and say, oh my gosh, I really loved your opening or closing, whatever.
Yeah.
But very rarely do they say, hey, by the way, when we were talking in this room, we actually agreed on X, Y, Z.
Yeah.
But it just wasn't relayed properly, right? So that piece in and of itself is a unique situation. Okay. And it's also interesting, again, that they reached out to the defense side and they didn't reach out to the prosecution's office, or they didn't reach out to the judge's chambers or something of that particular nature. They reached directly out to the defense side. So that's also another really important, unique piece to this, right?
Okay.
Having understand those 2 pieces, one of the jurors, for sure, we know, says that there was a unanimous, decision on counts 1 and 3.
Yep.
The other 2, as you said, were kind of through the grapevine from one person to another and then to the defense attorney. But I think with those 3 alone, it's enough to call the judge into question about what actually happened in that split second before the mistrial was declared, right?
Yeah.
So I'm going to take that back one step. And if I'm confusing, let me know. I will.
No, you're good. I just want to, before you continue on, I just want to add, that there is another, this morning, Alan Jackson, there's another motion, another affidavit filed by Alan Jackson. A 4th juror has come.
And you know what? I'm not surprised at that, because as much as this particular jury has been shielded as best as they possibly can, they're out now in the open, and now they're seeing everything that happened while they were in chambers and closed doors, and the support on both sides. So I honestly am not surprised that more and more jurors will be coming out. I think, the point I was getting at is, especially with this fourth person now, they have
And
enough.
they contacted Alan Jackson directly. So this is another
This
direct
person in
contact, not
direct
through.
contact, right?
Mhm,
Right.
yep.
And so the legal issue that they're facing is that when the jury sends a note,
Mhm.
the defense attorney and the prosecution technically is supposed to read that note before it goes out back to the judge and before the judge reads it on the record.
Okay.
That happened the first time.
Okay.
But it's my understanding that
Didn't happen the
the
second.
last time it didn't happen.
Uh-huh.
Okay. Now, the legal question is, did the defense attorneys have a right to object at that time?
Ah.
Because it's a double-edged sword, right? So should they have objected at that particular time and said, hey, judge, I know you're going to read this. I think they already anticipated a mistrial was coming and chose not to, on the record, say, we didn't have an opportunity to read this. No. Okay. The second issue is that the judge asked the juries, are you hung versus are you hung on all charges?
Right.
That's a legal distinction.
Okay.
That is really the issue that we have right here. Right. Because in all honesty, the jury could have voted not guilty on 1 and 3 and have been hung on just the second one.
Right.
But that distinction wasn't particularly made right before the mistrial was declared. And so that's what they're arguing. That's part A of what they're arguing. Whether or not they had the opportunity to interject, and all of this is all important because you want to keep the record clean and document everything, whether or not they had that opportunity right before the mistrial was declared on the record.
Okay.
The second issue that they're facing is if what the jurors are saying is true,
right?
1 and 3 was a unanimous decision. Does this concept of double jeopardy attach, right? Because when you have a mistrial, the indictments or the charges are still what they call live charges, meaning that they don't get dismissed in the due course that people think it gets dismissed. It's just a case that is still open and pending before the court. So they don't like dismiss the charges and then take out new charges. It's the same charges, right?
Yeah.
And that's why they have the status hearing closer to the end of the month to decide if the Commonwealth is going to move forward on all charges or not. But if there is this decision that was made unanimously, and it has to be a firm decision, right? Which is another legal term, meaning that all of them agreed and it wasn't like coercion.
Right.
Then this issue of double jeopardy could attach in this case against Karen Reed. And on the 22nd, the only thing that should be moving forward is that second charge, right?
Okay.
So this is, I mean, the case in general has been a lot and complex, but even just this little piece here is so complex and there's so many layers and there's so much going into it that it really is going to, I mean, you can see the ripple effects that it's having, you know,
already
with the FBI investigation and people being on paid leave. Like they're really looking at this, you know, information that's coming out in this case because it's important and it unfortunately happens a lot, but maybe not particularly in this way. And getting the attention that a lot of these other cases don't get, because I'll be honest with you, the Karen Reed uniqueness is not a unique situation. It happens. It's just that it doesn't get publicized and televised and you know, it's supporters, but it happens all the time. And so that's why all of this is so important. It's so unique. It's so interesting, right? Because you're like, oh my gosh, there's something else happening. Okay.
My question. Oh, go ahead.
No, I'm done. Go ahead.
My question is, look at it, them flips. You know, miss my mind. Hold on.
Well,
the note. So, did the note say they came to an unanimous decision on 1 and 2 or 1 and 3 or did it not? Like, did the judge choose not to
we
read
don't
that?
know. That's the issue. We don't know what the note said. And that's part of their argument, their motion is that they didn't have an opportunity. Number one, they didn't have an opportunity to see and review the note. And number two, that right before the case was declared a mistrial, they didn't have the opportunity to on the record make, you know, certain objections or arguments as it pertained to all counts. I think what we're hearing now is that in the deliberation room, they did decide,
Okay.
even though they didn't mark it on the, you know, verdict slip, that they decided that those counts were actually agreed upon unanimously, not guilty, right?
Okay.
And so that goes back to what I was saying about the verdict slip and the jury instruction. Jury instructions are difficult, even for attorneys. Sometimes you're going through it. The language isn't always straightforward. You know, sometimes it seems like it's contradicting itself. And so some of the questions is, you know, people have asked is, was there a miscarriage by the judge for not explaining that they could have voted on 1 and 3 and not voted on 2, and was that properly explained in the jury instructions, which they were given? So they were actually read the jury instructions on the record, and they were given a copy of it to go back into the deliberation room to use to, you know, decide this case. And so all of that is happening in this motion that the defense team filed. I have said pretty clearly that I think Judge Canoni, as a judge, because the judge's job, remember, is to be a referee, right? She is not the person that decides guilt or innocent. All she's supposed to do is make sure the facts come in appropriately when they're supposed to, and, you know, make sure everybody gets a fair chance. And so now they're kind of calling into question whether or not, you know, she did her job in that last piece in the instructions. And you know, from what I remember, I think she did, to be honest with you. I don't know if there was much more that could have been done, but I think it's what I can't see what they were presented with, right? But this is something that's being called into question right now. The last thing with this motion, which is, again, really, really unique, is the preservation of the identity of the jurors. So if you look at the docket sheet, the judge did issue an order that any of their identifying information, name, address, whatever, will be impounded, which leads me to believe that if a voir dire or questioning happens, it's going to be behind closed doors. Kind of sealed, like you won't be able to see that, because even though they have reached out to the defense attorney, I think, you know, they also in the motion labeled them as A and B and C. That is going to remain in place, because the fourth issue is whether or not the jury was intimidated, right? And that is a huge issue, not only for this case, but for other cases, because they've expressed throughout the case, or, you know, allegedly expressed that they were harassed or coerced by witnesses from the prosecution side, you know, and now did they feel pressured to make a decision in this case? I mean, the layers just keep layering. All whatever this hearing does take place, and it could happen on the 22nd, or it could be another day. It'll be really interesting to see how that all pans out, because there's so many moving pieces in this one particular motion that, I mean, you could talk literally hours on
about it,
you know. But the real question is whether or not, having heard all of that, whether or not 1 and 3 really is out, and whether or not they can only move forward on 2.
And actually, on that note, I just want to, because some of what you're saying, I think Alan Jackson tried to make a little clearer in this latest affidavit. So I'm just going to put it up. Hopefully we're still here. Okay, good. It's probably not the easiest to read, but I want to highlight number 2. I'll go through a couple of it, but he says in number 2, it says, on Monday, July 8th, I was contacted by juror D. Based on my conversation with that juror, that he was able to identify them. Juror D told me that they decided to reach out to me because they were uncomfortable, which is in quotations, with how the trial ended. They said that the last day was a whirlwind, quotations, and everything happened fast. They recounted from their perspective that the jury was brought in, the note was read, the mistrial was declared, and then they were rushed out of the courtroom. Following a brief meeting with the judge, the next thing they all knew, the jury was on the bus. They said that the end of the trial was very confusing. Going on, it says that The juror D said that it was very troubling that the entire case ended without the jury being asked about each count, especially count 1 and 3. They explained that they reached not guilty verdicts on count 1 and 3 and that the disagreement was solely as to count 2 and its lesser offenses. Juror D said that the jury actually discussed telling the judge that they had agreed unanimously on not guilty verdicts for count 1 and 3, but they were not sure if they were allowed to say so. And then number 7 says, the jury believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any of the counts. After discussion, the jury decided to inform the court that they were deadlocked and they expected that they would get further instruction about the remaining decided counts thereafter. Juror D explained it that they were confused and upset that such further instruction never came. They explained that the jury was excused and aboard the bus. When they were on the bus, the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen on count 1 and 3? No one ever asked us about those counts. And then I think it's the last one I'll read. The juror says that they remained very uncomfortable with the results. It did not feel right. And then they also said, Alan Jackson says that he asked this juror, would all the other jurors agree and acknowledge that they reached not guilty on count 1 and 3? And juror D said, without hesitation, every one of us will agree and acknowledge that we found Karen not guilty of counts 1 and 3 because that is what happened. And then anyway, so I think that is pretty much, the summing sentence, as they say in the legal world, of that.
I find this interesting that the judge didn't tell them about this, because through the entire trial, she was very informative and giving instructions day after day.
Yeah.
I was under the impression she saw the note and it's basically said not guilty on 1 and 3, and she chose not to say it. But this clears it up. They weren't instructed, or they
we
didn't
don't
feel
know what that note said.
They didn't.
Don't, right?
We don't know what the note said. But they didn't feel comfortable speaking up at that point. But like you were saying, she's the referee, so it should have come to her. There's 3 charges. Do you all, what about all 3?
Yeah.
Right. And that is a huge distinction, because sometimes people, ask about whether or not you can do like a jury poll, which is essentially when you go to each juror and you ask them if they agree with the 4-person. So the 4-person is the speaking piece, right?
Yep.
And so the 4-person reports what everybody says. Typically in cases when you actually have a verdict, the judge will say, 4-person, what have you reached? They'll say guilty or not guilty. And then the judge will say, as to all of you, how do you agree? And they'll say, yes, we all agree, unanimously. So I think that's why this, literally those last few words, hung on all counts, is going to be such a unique distinction in this particular case, because all that was asked of them is whether or not they were hung. And that comma after that is the part that Alan Jackson is saying now is the miscarriage of justice, because they really weren't hung on all counts. They were really only hung on 1 count, but it wasn't asked of them whether or not they were hung on all counts. And so, this 4th person almost is like the cherry on top of what person 1 was saying and 2 and 3 were saying to, their friends or family member, that if you were to ask all the jurors today, they would all agree, that 1 and 3 was, so it's,
a lot.
I find this is interesting, because I'm a correlate this to me being a maintenance man, and I'm painting a room. If I come to your house and I paint your house and you choose the color, the next question coming from me will be, what sheen? Okay, you want it in this color, but do you want it flat, semi-gloss, high gloss, satin, enamel? I'm going to ask you this. The judge was supposed to say, okay, which charge?
Because she has the knowledge.
Yeah, she has the knowledge.
She has the know the knowledge to say, hold on, there is a part 2 or part 3 to this question. It's not just a broad question. But one of the questions I have to something that you said is, when you don't object in the middle of it,
Right.
are you able to later say, hey, I meant to object. I'm sorry I didn't, but I got to object now? Is that even my understanding just from some of the other trials? I've heard judges say, you didn't object. And so if you don't object in that moment, you are saying, I agree, I'm okay with what's going on. So in this instance, it's like they're trying to go back. Can they?
You know, again, it was such a unique situation that we're in, because it could have gone the other way. They don't know how the jury was going to rule. What if the jury said, actually, we agreed guilty, took out 1 and 3,
Yeah,
right?
yeah.
Are you going to jump up and down and be like, oh, judge, by the way, we needed to know, right?
Yeah.
And so the theory in general that, yes, if you don't object, then essentially you waived your opportunity to do so at the time.
Yeah.
But the uniqueness about this case is that it's not only so much that the opportunity to object was missed, but that the jurors are saying they were uncomfortable. They were, they felt like an injustice was taking place.
Yeah.
They're fearful. So you have, again, another onion that you're peeling back. And it's not just so much that the opportunity was missed. It's the fact that the jurors, and that's why they read the Tui Rodriguez instructions, because they want to make sure the jurors understand what their obligations are, what their rights are. But did they feel coerced? Did they feel, fearful? Did they feel that they were forced, to reach a decision? And I think that's why it goes into those steps.
Yeah.
But the ultimate question is, despite all of that, did they actually reach a decision? And they're seeing that they did, and it wasn't brought to anybody's attention, right?
Yeah.
And so, is there a valid point to this motion? I mean, any defense attorney, if this happened to me, I'd be writing the same motions as well, right?
Totally.
And so now we're seeing that there's some, as they say, teeth to this motion, that people were actually unanimous on these counts, and that they don't feel it should move forward on those. And if it does, it's a miscarriage of justice. I mean, this is like screaming appealable issue.
Yeah. 100%.
It's literally going to be in textbooks for ages. Like, these are, I mean, you can make arguments. Obviously, the prosecution is going to have their stance and their arguments, but they're going to make arguments on both sides. Again, you had the opportunity, you didn't, but the jurors felt uncomfortable. Did the judge give the right instruction or not? Were they asked on individual counts? I mean, it's so many pieces. But I think the reality is that the more these jurors come out, and I wouldn't be surprised if other ones do, the likelihood that they're going to have a voir dire hearing, in closed camera, or some sort of closed session to keep the jurors' identity hidden, and each of them may be asked, like, how did you agree on this? And then there'll be a post trial hearing whether or not those counts should be moving forward, because the prosecution's already said they're going to retry this case, and I have every reason to believe that they will. But on what charges? What charges?
So there is and then we can move from this, but there is a world in which this in camera happens, or closed session happens, these jurors are asked, and the judge, even if they all, this is my hypothetical, even if they all say, yes, judge, we said not guilty on 1 and 3, could the judge still say, so what? Not so what, this is my version of it, but still say, so what? Because it didn't happen in the actual trial, she can continue to be charged. Could that still is that still a possibility?
So you're asking a lawyer, right? I'm going to say yes, it's always a possibility, right? But the reality is that it will create ripple effects. I mean, ripple effects. If each juror independently is interviewed and says that they agreed unanimously, and that there was an issue in the procedure in which that they believe they were supposed to report that, and she still says no, that's going to create some hot water.
Okay. Got it.
Super hot water.
I love it.
On top of the flames.
On top of the
already.
flame that's still flaming.
My
you know,
goodness.
Flaming.
from April, you know,
Yeah.
it's like the fire has not been put out. Like it is
No.
just only gotten bigger. So
One of the other things I wanted to ask you about is that a new attorney has entered the chat on this case.
Yes.
And one of the things that I've seen about that is that because jurors reached out directly to Yannetti and Jackson, they could be called as witnesses now because they had that direct conversation. So they could be called as witnesses. And so this additional attorney could be added to this case because he may be doing some direct on Jackson and Yannetti. Does that sound?
That sounds about right, because, you know, let's just take a step back from the overall case. We're talking about a very unique issue in the particular case. And yes, they could be witnesses for this one particular issue and still go on in the future and still represent her, right?
Okay.
But because they have what we call firsthand personal knowledge, meaning somebody came directly to them.
Right. It's not hearsay.
It's not hearsay, right? And so how do you substantiate that information other than putting the person who signed the affidavit in place? And the other issue with that is the jurors themselves are not going to come forward and say, hey, by the way, it's me. Yep. Juror number 4. Yep. I said that. So it's also a barrier to protect the juror that came forward, and the attorney is signing it under oath as an officer of the court and identified who that person was by all of the information they had at the trial, where they sat, you know, the number that they were. So that person, that affidavit is a good affidavit, even though it's coming from another person.
Yeah.
And that, again, is to protect the identity of the jurors, but give veracity to what they said.
Yeah.
Yeah. So
in that regard, though, feel free to interrupt.
No,
I'll keep going.
I'm intrigued.
In that regard, does Jackson's affidavit and his position and the things he heard feel stronger than Yannetti's, because Jackson got it directly from jurors and Yannetti got it from the friend and the intermediary and then the juror itself? Like there is a little bit of telephone. So does Jackson's feel a little bit stronger than Yannetti, in your opinion?
So I think that yes, you can look at them independently, but you're looking at the overall issue as a whole.
Together.
And is the overall issue together going to raise the issue of whether or not the 2 counts should be ruled on because there was a decision, right? I don't think, yes, you could use one independently of each other, but I think the reality is together, they're raising the same point. So it strengthens one, with the other, essentially. Yeah.
Got it. Okay. Any other questions for you?
I do.
Go ahead.
Do you know the Alberts?
Oh, we've been asking everybody. Do you know any of the Alberts? Any of the Higgins?
I don't. And, you know, the funny thing is I have tried. So I do live in the South Shore, like where, where Canton is. And in the beginning, I really tried to stay away from all of this because it has been a media frenzy, even back in 2022. Like, I mean, I remember one time I was actually driving by, this is before I even knew what was happening, but I was driving by the Canton police and I saw all these people out and they had signs. I'm like, oh, maybe there's a race in there. Everybody's rooting for Karen Reed. She must be some good runner because we got all these people out here on the street. And I'm like, wow, good for her. Like, I had no idea what was going on, but it was that many people. And then obviously as time went on, I was like, ooh, okay. I see what's going on over here. So I don't know them personally.
Okay.
I do live the next town over from Canton. So and it's crazy because you would literally drive down like a lot of main roads and see a free Karen Reed sign literally right across the street from We Love Canton Police. Like it's like a very polarized case. I mean, very polarized.
Yeah. Okay, well then our last question, if you feel comfortable sharing, if you're also like, I'm not answering that, obviously you're a lawyer, I'm sure you're used to saying that. Do you believe it was a cover-up?
Oh, I don't know. That's my real honest answer. I tried as best I can to watch the trial live to try to figure out, what was happening day to day, because there were just so many things happening. I think the reality is, I think there was definitely some missteps that happened. I mean, you cannot deny
100%.
this red Solo cups and why people were driving by the house if they weren't part of the investigation, and the text messages, back and forth. Those all scream red flags.
Yeah.
Does it rise to the level of cover up? I don't know. Clearly, the FBI, it's enough that the FBI is investigating and trying to figure out what happened.
Sure.
But I think there's so much, honestly, that we don't even know that happened, that we're literally just getting the tip of the iceberg of what we think happened. And it's only because of the result of this case and the ongoings with this case. But I'm sure there's much more that we just don't know. And I'm not sure, to be honest with you.
Yeah. No, I love it. I love it.
Good answer. Good answer.
Is there anything we didn't ask you that you want to say? Let me say that.
Oh, I mean, keep watching. Whoever's watching, it is definitely going to be ongoing. I will say that, also keep in mind that there is somebody whose life was lost. There is a family who is still mourning. I know that a lot of times people are, fantasized by this whole case, but we have to realize that John Okeefe does need justice. We need to know what happened. I think it's unfortunate the way that the investigation played out in court, because even on the day when the mistrial occurred, you could see his mom crying in the courtroom. And that's tough, right? Because even as a defense attorney, I recognize the fact that a crime happened, right? Or allegedly happened, right? And we still have to give credence to the fact that we do live in a world where sometimes people don't do what they're supposed to. And you put that away to the side, when you get these overzealous and media frenzy cases. So just to remember that, yes, Karen Reed also cannot be accused of a crime, but there has to be justice for the Okeefe family. And people have to understand and respect that. And I think for the most part, people have, but, keep that in the forefront, because that does get watered down when you have things like that come out, in the forefront. So.
Yeah. Yep. Thank you for that reminder. And I thought I was done, but we have a question in our Patreon, and I love to be able to tap into them when we have guests. And so the question is, I'm going to read it directly. Why are prosecutors allowed to bring the same charges to a grand jury an unlimited number of times until they get a true bill decision?
So I think the issue is that, again, that process is also sacred, right? What happens in the grand jury proceedings. It's, from what I'm being told, it's not so much that they bring it multiple times, but sometimes investigations take a while for them to gather all the information. And so you'll have grand jury sessions where only the detectives are involved, and it's based upon the detective reports. And sometimes they, get analysis that take months and months and months to discover. Like I have a firearm case where it took them 10 months before they could even reach an indictment. But that was because there was a fingerprint that was discovered, and we're dealing with that issue, but there was a fingerprint that was discovered, and it took them a while to actually get the true bill in place, because that was a new piece of information that they didn't have at that particular time.
Got it.
And so I think that's really what it boils down to, is as information comes forward, they do it. But once the true bill is issued and the indictment is issued, they're stuck with that, right? Obviously, they can take out more charges if the time goes on and things like that. But they're the Commonwealth, or in our state, they're called the Commonwealth of the Massachusetts. I think California is like the people, right? So they do have an obligation to foster justice, right? And so, because again, a lot of these crimes are not victimless crimes. There is a victim.
Right.
So you want to also make sure that justice is being adhered to. And so I think that's why sometimes they, bring cases or indictments multiple times or have multiple grand jury sessions, because they want to adhere to justice.
Got it. Thank you. Thank you for that. We're trying to get this scheduled, and I'm so glad we were able to have you on.
You
this was
are
so
amazing.
Good. I know. So thank you
Try
for
my
coming on
best.
and sharing.
Thank you
We
for
know you
having
have-
me. This was great. I loved it. I love the energy. I love you
Yes.
guys. Keep doing what you're doing.
Thank you.
It's really good stuff, really good material. And people don't know. And I think that's the other beauty about this case is everybody's a legal beagle now, right?
Yes.
And I
not a lawyer,
I love that because, you know, there are so many injustices that you should just know exist. And you're being forced to know now, which is great because then maybe not all of them will happen.
Right. Yeah, exactly. Well, we will maybe tap in another time, have you on again. But again, thank you so much. We appreciate it. And we'll continue to be watching this case.
Absolutely. Have a good day, guys.
You too.
Cool. You too. Nice meeting you.
Nice meeting you. Bye.
All right.
All right. So before we get out of here, there's one more thing. I know we've been on for a while, but I hope you guys are enjoying this episode. I hope you enjoyed that interview. She was amazing. But before we go, something else happened in this trial yesterday. There was a meeting. It was a meeting with the select people.
Selectmen, the councilmen.
There was a Canton Select Board meeting, and we all remember that
on the agenda,
Chris Albert is a selectman. And so there was this meeting, and in this meeting, people in the town get to come up and say their piece. And it was chaos, y'all. It was chaos. So I just want to play a little bit of the first person who comes up. Is just funny. It's not funny because it's very serious what she's claiming, but it just starts the chaos. And then the other people in the community get up to say more things. And I think what's important, what was so interesting is to hear people from that community speaking on this case. And, you know, we don't live there. So we have all of our opinions, but there are people there. And so just like, Morjieta was saying, there are people on both sides. And so again, this is just like a glimpse of that. And then at the end, so it's like a maybe 3 or 5 minute clip, but at the end of the clip, there's a statement made, and Chris Albert makes a statement because remember, he is a selectman. So he is there. He is in this meeting, hearing all of this. He makes a statement, and then there is an overall statement made about Kevin Albert as well. So here we go.
Public comments is an opportunity to listen to residents' feedback and concerns.
This clown town of Canton has caused nothing but harassment to a small business and caused extreme emotional distress to Jeff's and I personal relationship. This harassment needs to end.
Why were the Canton police officers in the Sallyport at 5 p.m. on January 29th? And why was an ATF agent also in the Sallyport?
What frightens me most is even after watching the same trial for 10 weeks, so many still blindly trust and follow the corrupt to bring justice for John Okeefe. Rather, they chose to keep supporting those who have factually been proven to be corrupt and dirty.
Thank you, Ms. O'Donnell.
To those
Ms. O'Donnell, that's it.
who find our fight for truth,
I'm going to ask you to
justice,
settle down.
and our American rights
I'm going to ask you to leave,
so
Ms. O'Donnell.
unacceptable to tonight.
Officer.
I quote Captain John Paul Jones, 1779. I have not begun to fight.
Thank you, Ms. O'Donnell.
Come on, we're in crisis for crying out loud. I know it's my imagination. I know it's my imagination.
All right, folks.
Policies and procedures are great, but there's no consequences when they're not followed. Just rhetoric that we'll do better next time. That just doesn't cut it. The Canton Police Department and this town is facing countless and costly lawsuits as a result of their actions. We do not feel safe, and that is why. Okay, I'm not speaking for you because you're part of the selected few. I'm talking about me, common folks. I'm talking about me, the random citizen. Anyone who's related to the McAlberts, you're safe, but not us.
Thank you, Ms. Lombardi. Ms. O'Donnell, you said you were going to be quiet. You were disruptive.
All right, can we just start our meeting? What do we do with her? I'm right, though. I may be disrupting the meeting, but I'm right, and it's my fucking right.
Thank you, Ms. O'Donnell. Thank you. We have 2 statements to read. Mr. Albert, do you want to go first?
Yeah, I'll go first. Okay, as many of you know, I've had 2 recent verbal altercations with members of the public outside of my role as a select board. Despite the tremendous harassment, stress, and anxiety that my family, extended family, and I have been subjected to over the past 16 months, my interactions were inappropriate. And as an elected official, I am held to a higher standard. And I understand that the residents of Canton expect public officials to always conduct themselves professionally and focus on the business of the town. I apologize for my recent reaction and will refrain from any further public incidents that are unbecoming as a member of this Canton Select Board. Thank you.
Thank you, Mr. Albert. An additional statement, Chief Rafferty has placed Kevin Albert on paid administrative leave while an outside, and please be quiet, while an outside independent investigation is being conducted relative to his actions in a case he investigated with Michael Proctor approximately 2 years ago. Kevin Albert was placed on leave on June 13th and will remain on leave until the results of the investigation are provided by the outside independent investigator. All right.
All right. Hold on. You had enough. She did not, her voice didn't elevate, lower, and she kept reading what she had to read. Yes.
She is ready for the smoke.
And we haven't begun to fight.
Listen, the other lady said that this is a clown town. I
Yeah,
said, what
clown
is
town.
happening?
Yeah. That
Oh man, I was watching that last night. Like, what is happening in the town of Canton? Something has to be done.
I can only imagine how many people have been wrongly accused, wrongfully arrested in that town because there was no internet. There was no way of letting people know. But now it's known. And this is why it's so crazy. This is why this thing will blow the hell up if it's found out there's corruption. Man, you have to go back 30 plus years.
Well, what's interesting is one of the ladies, I didn't play it just because it got to be long, but she went through a number of incidents concerning the Canton police, including there's a new case right now that's being looked at that involves some of these same key players.
I bet.
Of a woman. I think her name is Sarah Boone or Birchman, something like that. I can't remember her exact name. I mean to look into it actually, because it involves some of these same players. And she goes through these different incidents and she's basically like, y'all are corrupt. She's the one who said it's always oops, we're sorry, and it's going to be we didn't mean to, and so she's saying something has to be done. So anyway, there is a bunch of stuff that happens in there. That was just a couple clips. I got that video specifically from a YouTube page called Young Jerks, but it is streamed on the Canton police page, or they have like a councilman select board page. So you can either stream it there, or I got it from Young Jerks. I think their logo was in there. I just wanted to be clear and give credit to where I got the video from. But anyway, that is.
I also want to say,
ahead.
We had our last episode. We were talking about, man, what's the chances of them creating this conspiracy? You know, how do you get so many people involved and to tell all these lies at one time? At that point, I was on that boat. I was like, man, how could this happen? But if you got 30 plus years of practice, you can make that happen.
100%.
Easy. And they've had 30 plus years of practice because all these officers have been in the same position, same town, having the same criminal cases happen. They've been practicing
100%
this whole time. So that is possible for them to
get good at it.
And all of a sudden this case come up.
Perfect or close to it.
It's muscle memory.
Yeah. And her name, the case that I'm talking about, that is with these same players. Her name is Sandra Birchman. That is her name. I have to look into it. I'm not sure if we'll bring it to, I'm not a lawyer, or to the debrief, but I need to look into it. That is her name if you want to look into it yourself. All of that to say, I hope y'all enjoyed this episode. We did a lot.
Yeah,
we did a lot on this episode.
Good.
Thank you for joining, for watching. Thank you again to our guest, attorney Morjieta. We appreciate you being on, and we will be back next week Okay, you can follow me on I'm Not a Lawyer, but on all the platforms. Make sure you like, subscribe, share this podcast, like and subscribe to the page. Amen. And then where can we find you?
Gooseby. You can find me at GOOLZBY on IG.
Until next time, we'll be back next week, and I think we got a guest.
Mm-hmm.
And join the Patreon if you want to watch these episodes live. Do it with the co-counsel, aka co-conspirators. You can join the Patreon. The link is always in the description. Merch on the way. That's what I heard. All right, that's all. Bye.
No. Courts.
Adjourned. We love it.